of Mrs. Martin's claim. In particular...
But didn't the plaintiff establish their cause of action at the trial court? I mean, the trial was, what, 2 or 3 weeks long with several witnesses?
It was, and the plaintiff certainly put on evidence. We put on a defense to that evidence, but the Martin jury was not permitted to assess the evidence for purposes of deciding whether Mrs. Martin had proven either a product defect or negligent conduct or fraudulent statements. Just the opposite.
Well, of course, that's the very question. Why should they? I mean, the verdict form from the Engel case has all of those findings.
Well, it has findings that Reynolds sold cigarettes that were defective. Let's start with that one on strict liability. Judge Clark, that finding does not say that every cigarette that Reynolds ever sold was defective, nor does it say that the Lucky Strike cigarettes, the brands smoked by Mr. Martin, were defective.
Well, but it sure says R.J.R. Reynolds Tobacco Company's cigarettes were defective.
It says cigarettes were defective. It doesn't say all cigarettes, and it doesn't say Lucky Strike cigarettes. So the question is whether you can infer from the way the Engel case was tried that that finding necessarily encompasses all cigarettes. And the answer to that question is no, because...
I'm not sure how you can even argue that. You would have to infer that when the Supreme Court clearly said this case is res judicata. And even if a federal court finds that the Supreme Court was in error, and I'm not sure if that's on appeal to the 11th or not, when the Supreme Court tells us to do something, we do it. It doesn't go the other way.
Absolutely, Judge Clark. But with respect, what the Florida Supreme Court said was that the findings are res judicata. Right. And the question is what that means.
Well, that's what I would like to ask. In reviewing your briefs and the appendices, which were very helpful on both sides, but my question is, tell me the kind of case you think the findings in Engel would apply in. What type of plaintiff does not have to relitigate the type of issues involved here? Or what kind of plaintiff and what kind of issues are covered by Engel?
The findings have the very significant consequence, for instance, of establishing both generic causation with respect to some 20 different diseases and generic addiction causation. Historically...
Okay, let's stop there because this is a complex case,
okay.
and I appreciate that answer. So a plaintiff doesn't have to prove that... we'll use Mr. Martin as a generic plaintiff,
sure.
But a plaintiff doesn't have to prove that cigarettes cause lung cancer, correct?
Right.
So that finding's binding on all juries, all class members, right?
We don't question that finding. Historically, the way smoking and health cases were tried, a plaintiff like Mr. Martin would have to prove...
I understand that. So, okay, that's the first finding you would concede as binding. Let's go to the next finding you would concede as binding. I'm trying to help you show us what kind of case is properly covered by Engel, how this case differs.
I think what you do is you take every finding for what it says, and then you apply it to the circumstances of the later case.
Okay, what kind of cigarettes are covered by Engel?
Well, that's exactly the point. We don't know.
Well, but isn't that a problem for your case? Because if you don't know what kind of cigarettes are covered, how is a plaintiff, a subsequent Engel plaintiff, to apply the decision from the Florida Supreme Court? Is every cigarette going to have to be litigated?
The question of defect certainly has to be litigated because an essential element of the claim, of any individual claim, is that the particular plaintiff before the court have suffered an injury that was proximately caused not simply by smoking but by a defect. The Engel verdict establishes that Reynolds sold defective cigarettes, but we don't know which ones. We don't know if it includes Lucky Strikes. And it is...
But their response to that argument in their brief was that that's, quite frankly, your company's failing, and your company should have litigated and distinguished between which cigarettes were not and which were defective.
Except that it was the plaintiffs in Engel who chose to make not only broad-based attacks on all cigarettes, but also numerous alternative claims going only to certain types of cigarettes and certain brands of cigarettes. Let me give you just one example to try to make that point. A significant part of Engel involved challenges to cigarette filters. There were allegations that the ventilation holes were put in the wrong place, allegations that the filters had glass fibers, and so on. The Engel verdict could have rested on a defect finding as to filtered cigarettes. If it did, it would have no conceivable relevance.
But that seems to me to be analogous to an argument that one sometimes sees in criminal law, which is that a general verdict can be a defective verdict when the jury could have considered alternative theories of liability and the court can't determine which one. Here, the plaintiff, let's say you're right, the plaintiff made a broad-based attack, said all R.J. Reynolds cigarettes were defective. Isn't it R.J. Reynolds' obligation to come forward with some type of an affirmative defense or some type of defense and say, not Lucky Strikes, not unfiltered cigarettes?
Well, we did...
I can follow up on that question. The points that you're raising, weren't those brought to the attention of the Florida Supreme Court?
No, they weren't.
On whether or not...
On the merits briefing, of course not on the merits briefing, but remember the posture of that case. When the case was before the Florida Supreme Court on the merits, we defended the third DCA's decertification decision. The plaintiffs as appellants in the Florida Supreme Court defended the original B3 certification. The plaintiffs did not ask the Florida Supreme Court in the alternative to decertify with res judicata effect. So the state law res judicata arguments and the federal due process arguments didn't arise until the Florida Supreme Court issued that decision sua sponte without either party having advocated it for it.
Well, and that's my question, really. When the Supreme Court issued its opinion in December of 2006,
yes,
the issues that you're raising now were certainly a concern, and it seems that they would have been raised in the Supreme Court if nothing, if at least a motion for rehearing. But if you have those kinds of concerns, those should be addressed at the Florida Supreme Court, rather than saying to us, the Florida Supreme Court issued this opinion, this very substantial opinion in 2006, but we think it wasn't quite right in these respects. That just seems to be an argument that should have been made to the Florida Supreme Court.
With respect, that's not our position at all. We are not attacking Engel in any way, shape, or form. We are asking you to decide what is the most sensible understanding of the...
And to answer that, I appreciate that. Let's get back to what findings are covered. You conceded that causation is covered. Mr. Martin doesn't have to prove to the jury that cigarette smoking caused his lung cancer. Why don't you, if you will...
Oh, no, absolutely he does.
All right,
what he doesn't have to prove is that, in general, cigarette smoking causes lung cancer. There's a traditional distinction in these cases between what's called generic medical causation and specific causation. What is established is the general principle that smoking causes lung cancer. There's a further question about whether the individual plaintiff's cancer was caused by smoking, and that issue would be open in any progeny case. That much I don't take to be disputed. But in order to establish tort liability, a plaintiff has to show not only an injury caused by smoking, but an injury caused by a defect. And if you don't know what the relevant defect is, Judge Thomas, you asked a question about the special verdict. The general verdict may or may not have been good enough for purposes of Engel itself, but Florida law is quite settled on the point that if there's a general verdict, it may be perfectly valid as a general verdict in one case, but if you can't tell from that verdict which of two different theories the jury rested upon, there's no res judicata effect in a later case. That's the rule that we're invoking, and it is a bedrock rule of Florida preclusion law, and Mrs. Martin hasn't cited anything to the contrary. Judge Clark, to come back to your question about what was or wasn't litigated in the Florida Supreme Court, it is true that on rehearing, after the original decision, the question of preclusion obviously arose for the first time, and we filed a rehearing petition making many similar arguments to the ones we make here. What should you do with the denial of rehearing? The answer is nothing, because first of all, denials of rehearing don't have precedential effect. But more particularly, with respect to this case, the plaintiffs opposed our rehearing petition precisely on the ground that all of our preclusion and due process arguments... The only point I was making there was that those were issues for the Supreme Court, not for this Court. No, I don't think that's right. The plaintiffs told the Florida Supreme Court that the arguments we have been trying to raise were premature before the Florida Supreme Court. So it can't possibly be correct that we were too early before the Florida Supreme Court in Engle, but now we're too late. That can't be right. So I don't think they get anything from the denial of rehearing in a case where they themselves told the Florida Supreme Court that these arguments should be...
Yeah, I agree that a denial of rehearing has no precedential value.
Okay, and then the only thing you have is the Florida Supreme Court's merits decision, which we're not fighting in any way. We're simply asking you to construe the order to give res judicata effect to particular findings of fact as a perfectly straightforward invocation of issue preclusion. Issue preclusion attaches to individual findings of fact, and it is limited to findings that were actually and necessarily determined by the first jury. I'm into my rebuttal time, so I'd like to reserve the balance, if I may.
May it please the Court. I'm Robert Lohr here on behalf of Matilde Martin. I think it's important to note that although Reynolds tries to phrase its argument as if it's not disagreeing with the Florida Supreme Court, what it asks you to do is overrule the Florida Supreme Court. Mr. Katz has just said these findings, because they came from a generalized verdict form, cannot enjoy res judicata effect in our trials. That is precisely the issue that the Florida Supreme Court said that they do enjoy res judicata effect. These issues were raised repeatedly in the course of Engle. What we're doing now is completing a three-phase trial plan that the trial court in Engle came up with. That plan was appealed numerous times. This didn't just take one trip to the Florida Supreme Court, multiple trips to the Third District Court of Appeal and then the Florida Supreme Court. That trial plan has been upheld all the way through the Florida Supreme Court, who merely said the Phase 3 trials all contain individualized issues, so they cannot continue in the rubric of the class action. The court was faced with a dilemma at that point. Now that these were going to be separate cases, how could the court accomplish a Phase 3 trial as the trial court had anticipated? And it came up with what I would call a rather elegant legal conclusion or solution to that situation, and it provided res judicata effect to those findings by the original Engle jury. Reynolds has attempted to phrase those as findings of fact. They're not just findings of fact. They're findings of legal issues, of negligence, of product defect, of fraud by concealment.
That's true, but those determinations were not as to liability. Is that correct? Those were as to, as I understand the Engle opinion, those were as to the conduct of tobacco. That's correct.
They dealt specifically with the conduct of tobacco, and the Supreme Court told us that issues of causation would be decided by these Phase 3 juries on the issue of comparative fault.
And I think that's sort of the point that the appellant is suggesting, is that the findings, or the res judicata findings or determinations from the Engle class action in Phase 1 were much more general, and that your client was required to prove specifically, in order to show that the appellant is liable for the damages, needed to prove specifically that Lucky Strike, not just that any or all of the cigarettes that RJR manufactured, but that Lucky Strikes in particular caused cancer.
And what we in fact proved, the first question the jury had to answer was whether addiction to R.J. Reynolds cigarettes, which in this case was Lucky Strikes and virtually only Lucky Strikes, caused Mr. Martin's lung cancer. So we did in fact prove, and one way to view this is the Engel trial went on for a year. There was a large body of evidence that was presented. We're now in phase 3 individual trials, and what we did was we took a subset of that evidence and we presented it to the Martin jury. That subset included a lot of evidence regarding Lucky Strikes, regarding the non-filtered cigarettes that Mr. Martin smoked. It was this jury's determination then as to whether the conduct of R.J. Reynolds was a contributing legal cause of the death of Mr. Martin. The Supreme Court spent a long time in the Engel decision and quoted extensively from the Mullen case, a Fifth Circuit case, in describing how by doing it that way, by taking all issues of causation and deciding them in the comparative fault context, we avoid problems of the Seventh Amendment of the U.S. Constitution or Article 122 of the Florida Constitution. We have to avoid having the second jury consider or reconsider the same issues that were considered by the first jury.
So I think, and correct me if I'm wrong, what I think I'm hearing you say is that in this case, in determining whether or not Mr. Martin was a member of the Engel class, that in making that determination, the jury necessarily determined that Lucky Strikes or any other cigarettes produced by RJR were addictive, and thus caused cancer, his cancer.
They specifically concluded that the Lucky Strike cigarettes manufactured by R.J. Reynolds addicted Mr. Martin.
So that's rolled into the determination of whether or not he was one of the Engel plaintiffs.
Whether he was a class member or not, correct. But then it went further than that.
In fact, the first question on the verdict form is, was addiction to R.J. Reynolds Tobacco Company cigarettes a legal cause of the death of Benny Martin?
And again, that question was compelled by the Florida Supreme Court. They told us that that was the definition of class membership. And it makes perfect sense when you look at the type of case this is. You know, Reynolds has pointed out that you could dream up a case, for instance, with an automobile is the example they use, that explodes when hit from behind because of a faulty gas tank. And if that's the defect, it wouldn't be fair to allow a second jury to come in, or a second plaintiff to come in and say, well, I was injured when I had a head-on collision with a tree. The Supreme Court considered those issues. In fact, the Mullen case reads, the dissent in the Mullen decision from the Fifth Circuit reads like a summary of R.J. Reynolds' brief. The dissent in the Engel court, Justice Wells actually adopted that and said, I disagree with the majority's citation of Mullen. I agree with the dissent in Mullen. The reason it makes sense in these cases, I would propose the reason the Supreme Court did this, is that Engel class members only get killed or only get ill in one way, by cigarettes. Nobody can come in and say, well, I set the cigarette next to my bed and it caught my house on fire. Nobody can say I lit the cigarette and it blew up in my face. Engel class members get ill and die because they become addicted to cigarettes. They smoke them compulsively, 20 to 30 to 40 a day for 20 or 30 or 40 years, and the toxins in the cigarettes finally amount to causing disease. So we don't have a situation where you can say that maybe these other defects were involved. All of the defects, all of the acts of negligence considered by the Engel jury were merged in the decisions that were reached and then were then given race judicata effect in this case. One of the reasons that makes a lot of sense also dovetails into the case-specific questions that are before you regarding reliance with Mr. Martin, reliance to the fraudulently concealed information from the defendants. The jury heard information that this very addiction that the Supreme Court told us we must consider affects the way addicted persons hear messages. It makes them uniquely susceptible to the type of enabling voice that they heard from this industry for over 50 years. The jury heard that Mr. Martin particularly was heavily addicted due to his young age when he started smoking, the heavy amount that he smoked, the fact that Lucky Strikes had 3 times the amount of nicotine in them that modern full-flavored cigarettes have. we presented evidence that that enabling voice is heard by addicted smokers. It was undisputed in this case that Mr. Martin heard that message. The defense experts, the plaintiff experts, everyone agreed that the message was so ubiquitous that it reached Mr. Martin. So we have a very susceptible person. We have a message that reached him, and the whole purpose of the message, based upon Reynolds' own documents and those of its co-conspirators, was to keep people smoking. The message was not quietly whispered in someone's ear. It was designed, according to their documents, to create a psychological crutch and a self-rationalization for an addicted smoker to continue smoking. They were telling these smokers, cigarettes aren't really addictive. Anyone can quit. The addicted smoker hears that as, well, I'm under stress right now. The cigarettes help me deal with the stress. I can always quit later. They're not really addictive. Anyone can quit. The smoker heard the message from the defendants and their co-conspirators that they haven't really proven cigarettes are harmful to you, and if they ever do, we'll take the substance out that's harmful. Or, even if we can't, don't worry, you can always quit. This message, we showed the jury, was effective in the United States. Several of the men who wrote or edited Surgeon General reports testified to this jury and showed them how when the health scare first started in the early 50s regarding cigarettes, cigarette sales started to plummet. Per capita use took a nosedive. People were listening. That's when this conspiracy started in 1953, and cigarette consumption went right back up. The next time it happened in the mid-60s when the first Surgeon General's report came out, cigarette sales started to plummet.
But that's a whole lot of generalities. Where's the evidence that Mr. Martin relied on the advertising?
The difficulty we face in these cases is that Mr. Martin died while the conspiracy was ongoing. We can't have direct testimony from him regarding its effects. We know he was one of the persons that this message was aimed at. We know he was uniquely susceptible to it. We know that he heard the message. And Florida law does not require direct testimony of reliance. The cases we've cited in our brief, State Farm v. Weiss, Clay versus Humana, all of these cases stand for the proposition that not only can you prove reliance by circumstantial evidence, but in many cases you must, and this is one of them. It would have been impossible for Mr. Martin to say, had I known all the information they were withholding, I would have done something different, when the information was still withheld when he died. So we've presented testimony that the jury could reach that inference. In fact, the Clay versus Humana case from the 11th Circuit, applying Florida law, indicates the very nature of a message can lead to an inference of reliance. We know from the Penzel case here in Florida that even if a person hears contrary evidence coming from other sources, it doesn't mean that he can't justifiably rely upon a fraudulent statement. So we have...
In other words, it was a jury question.
It was a jury question. They drew reasonable inferences from the evidence, which we instruct them that they can do. Judge Terrell considered these. He sat through this 3-week trial, saw all the evidence, and reached the conclusion that there was adequate evidence, and in fact there was.
Before your time expires, counsel, would you address the punitive damages question?
The punitive damage question here is really twofold. They first pointed to 768.73, giving a presumptive limit of 3 to 1. We have asserted that that statute does not apply based upon the Coral Cadillac case, which draws a distinction between the type of commercial transaction that was included in the Alamo case cited by the defendants and the simple fraud in the sale of a consumer product. Nowhere in the statute does it say that it relates to fraud. Nowhere in the statute does it say that it relates to a consumer product. Additionally, the Alamo decision quotes the entire section of 768.73 that's applicable here. Neither brief did. The Reynolds brief used an elliptical and a footnote at the end. The sentence after the elliptical says that that section does not apply to class actions. And this was clearly a class action. Mr. Martin could only recover because he was a member of that class. If we move on to the issue of due process, the State Farm case, the U.S. Supreme Court case, the Gore case by the U.S. Supreme Court, all of those cases point out that the most important factor to look at is the reprehensibility of the conduct. State Farm reversed a 145-to-1 ratio of punitives to compensatories, and the Gore case reversed a 500-to-1, and yet the Supreme Court in both opinions saw fit to point out those cases involved commercial injury only, no repeated acts of misconduct, no intention to harm anyone, and no acts of deceit or fraud, all of which are present in this case. So we have here a compensatory award of $5 million before reduction, a punitive award of $25 million for a 5-to-1 ratio that clearly every piece of evidence in this case points to egregious conduct, extremely egregious conduct, more like what was involved in the Williams case before the U.S. Supreme Court, which was reversed on procedural grounds, sent back to the state court, came back to the U.S. Supreme Court with a 97-to-1 ratio, and they denied cert. Now, I know you don't place precedential value on the denial of cert, but it does point to the fact that at least the cases the Supreme Court has considered do not involve this type of conduct causing injury and causing death. I would further point out that Judge Terrell's order denying the motions for new trial and remittiture actually contained all the findings that are necessary to deal with this issue, either on a due process basis or under 768.73. This jury found, and he noted in the order that they found by clear and convincing evidence that the standards in the Florida standard jury instructions had been met, that they considered the appropriate information and came to a reasonable verdict that he saw no reason to overturn. There's simply, we conducted a Phase 3 trial, as we were ordered to by the Florida Supreme Court. If they didn't mean this, what did they mean? If they didn't mean to do the case the way they did, Reynolds says the only preclusive effect that the findings other than addiction and disease causation have is to stop them from uttering two sentences in the trial. We've never done anything that was negligent, or we've never made a defective product. Can you read the Engel decision in that manner? Is that what they meant as a pragmatic solution to a unique problem that's not likely to be repeated? That is a tortured reading of Engel. There was no error in the record below. The jury considered these issues and decided them. Judge Terrell saw no reason to, reverse that, and I would respectfully suggest this Court should not either. Thank you.
Thank you, counsel. Rebuttal.
Mr. Lohr said that the preserved findings have res judicata effect. That's absolutely right, and it makes perfect sense as a statement about issue preclusion. His theory has problems regardless of whether he views this as a matter of issue preclusion or claim preclusion. He either needs to take the position that the Florida Supreme Court in Engel, for the first time in history, applied issue preclusion to facts that a prior jury may or may not have resolved, or he needs to take the position that the Florida Supreme Court in Engel, for the first time in history, applied claim preclusion without the adjudication on the merits of any individual claim. With respect, we don't think that is a reasonable reading of a straightforward instruction to apply res judicata law to certain findings of fact. He mentioned the first finding in Martin. It was a finding that addiction caused Mr. Martin's cancer. That's absolutely right, and it subsumes a further finding that smoking caused Mr. Martin's cancer. But that isn't enough under the governing law, and the Florida Supreme Court spoke quite clearly on this particular point. They said repeatedly that legal cause remains an open question, and they twice defined legal cause at page 1263 and then again at page 1271 as requiring a connection between the plaintiff's injury and not simply smoking, not simply advertising, but misconduct by the defendant, exposure to a defective product or reliance on fraudulent statements. He discussed the Mullen case. The Mullen case involves jury trial questions and the concern about reexamination under the Seventh Amendment of the U.S. Constitution and Article 1, Section 22 of the Florida Constitution. You can solve the reexamination problem if you simply assume by fiat that any fact that the Engel jury could have resolved against Reynolds. It's did resolve against Reynolds, that would eliminate the possibility of reexamination, but it would create what is, in our view, a very obvious due process problem and very obvious inconsistency with settled Florida preclusion law. We don't think Engel can fairly be read as accomplishing all of that. Thank you very much.
With that, the court stands adjourned.